Do you need probate and court to settle a small estate? Today we're diving into an important topic that many families face during challenging times: how to avoid probate when the deceased only has personal property. You file a small estate affidavit to transfer personal property. If you recently lost a loved one and are dealing with the process of settling their estate, understanding this process can help significantly things and ease some of the stress. Before we get started, I want to mention that I'm not an attorney and the information shared in this video is for educational purposes only. Let's define by defining what a small estate affidavit is. Essentially, a small estate affidavit is a legal document that allows the heirs or beneficiaries to claim or transfer personal property without going through the often lengthy and expensive formal probate process. This document is especially useful when the estate's value is below a certain threshold. In many cases, a small estate affidavit can help speed up the process, making it easier to access personal belongings, bank accounts, and other assets. In simple terms, if your loved one's estate qualifies as small under your state's legal guidelines, you can use this affidavit to legally transfer property without the full probate process. It's a way to cut through red tape when dealing with things like household items, vehicles, or even certain types of bank accounts. Before you consider using a small estate's affidavit, it's important to determine if the state qualifies as small estate under your state's law. Although the exact amount can vary, California sets a limit of $184,500, the total value of the estate. This amount excludes vehicles and vessels. Typically, if the value of the deceased person's asset is below this limit and does not include real property like a house, the estate might be considered small. Some key points to keep in mind: personal property only. The affidavit generally applies to personal property, not real estate. If the estate includes a home or land, you may need a different process. Debt considerations. Ensure that any debts or liabilities of the deceased are taken into account. In some cases, if debts exceed a certain amount, the affidavit might not be applicable. State-specific rules. Laws can vary significantly from state to state. In our state of California, for instance, there are specific thresholds and requirements, so it's crucial to review local laws or consult with an attorney to confirm eligibility. Once you determine that the state qualifies as a small estate, you can begin the process of transferring the personal property using an affidavit. Let's break down the key steps. 1. Gather information and documents. Start by collecting all necessary information about the deceased, including the full legal name, date of death, and a list of personal property items you wish to transfer. You'll also need documentation such as death certificate, any wills or codicils, and a complete inventory of the assets. Obtain the correct affidavit form. Next, locate the appropriate small estate affidavit from your jurisdiction. In Orange County, go to courts.ca.gov to find your forms. DE 130, California Small Estate. DE 161, Itemized List of Assets. DE 221, Spouse or Domestic Partner Property Petition, or DE 160 if you are not the deceased spouse. 3. Complete the form accurately. Fill out the affidavit form carefully. This usually involves identifying information, details about the deceased and the person or persons filling out the affidavit. Asset descriptions. A clear description of the personal property you wish to transfer. Be as detailed as possible. List serial numbers or items, or provide specific descriptions for unique possessions. Also provide proof of ownership. Hardship information. Identify who is entitled to receive the property. If there are multiple beneficiaries, make sure all names and relationships are correctly stated. 4. Affirmation under oath. The affidavit must be signed under oath. often in the presence of a notary. This notarization is a critical step because it validates the document as true and accurate account of the estate's details. 5. Submit the affidavit. Once the affidavit is signed and notarized, it may need to be submitted to the relevant institution. This could be a bank, a financial institution, or another entity holding the personal property. Some institutions require a copy of the affidavit along with the death certificate and other supporting documents before they release the assets. Number 6, follow up record keeping. After submitting the affidavit, follow up with relevant parties to ensure that the property transfer is processed correctly. It's also a good idea to keep copies of all documents and correspondence for your records. While the small estate affidavit process is designed to be simpler than the full probate, there are still a few common pitfalls to watch out for. Incomplete documentation. One of the most common issues is not having all the required documents. Make sure you have multiple copies of the death certificate, a clear inventory of assets, and any supporting legal documents. Errors on the form. Take your time to fill out the affidavit correctly. Mistakes or omissions can delay the process or even cause the affidavit to be rejected. Notarization issues. Ensure that the affidavit is properly notarized. Some institutions may reject a document that isn't signed before an approved notary. Consulting professionals. When in doubt, it's always best to consult an attorney who specializes in probate or estate planning. They can provide guidance and help you avoid potential missteps. A tip for success is to keep a checklist of all required documents and steps. This will help ensure that nothing is overlooked during this often emotional and stressful time. Let's walk through a brief example to illustrate the process. Imagine you're the only child of a recently deceased parent, and their estate qualifies as a small estate because it only includes personal property like jewelry, a few pieces of art, and some bank accounts. First, you'll gather the death certificate and any existing will, and a detailed inventory of these items. Next, you'll download the small estate affidavit from your county clerk's website and carefully fill it out, listing all your parents' details, a description of the assets, and your information as their heir. After signing the form in presence of a notary, you'd submit the affidavit along with the necessary documents to the bank holding your parents' accounts. With everything in order, the bank processes the affidavit and you're able to transfer the funds to your account without going through the full probate process. This streamlined process saves time, money, and reduces emotional stress during a difficult period. In summary, a small estate affidavit is a powerful tool and can help families transfer personal property quickly and with less hassle than the traditional probate process. By understanding eligibility requirements, carefully completing the form, and following up diligently, you can assure the transition of assets is handled smoothly. Remember, always verify the state qualifies as a small estate under your state's laws. Gather all required documents and complete the affidavit accurately. Don't hesitate to seek professional help if you run into questions along the way. If you found this video helpful, please give a thumbs up and subscribe for more practical advice on estate planning, probate solution, and senior living tips in our beautiful community. Also, leave any questions you have in the comments below. I am here to help. Thank you for watching and take care.